Hello and welcome back to Business Law. This week we're going to be discussing employment law and agency law. Now we're going to start first with employment law. Now employment law is really a relatively new area. Um, Back until really the 1930s, there really was very little employment law per se. There was a laissez-faire attitude. People could work for whom they wanted to, and employers can hire whom they wanted to. There was really very little regulation of employee-employer relationships. That started to change starting in the 1930s. Of course, the 1930s was the time of the Great Depression, and during that time and thereafter, a number of statutes were passed that started to regulate the relationship between employees and employers. Now, probably the first important piece of legislation was the Norris-LaGuardia Act. Norris and LaGuardia, they were congressmen. Now, you should know who LaGuardia is. He's not just the person whom LaGuardia Airport was named after. He was a mayor of New York, and he kind of gained national prominence during a newspaper driver strike. He read the comics to children over the radio. But when he went to Congress, he sponsored and it was eventually passed the Norris-LaGuardia Act. Now, what did this do? Well, on paper, it gave employees the right to organize. That's it. But it didn't give them any specific powers to accomplish this. So it really was kind of empty. It just gave them the right to organize, but it didn't give them the tools to organize. And what do we mean about organize? Well, ultimately, what we're talking about when we're talking about employees organizing, is unionizing. So on paper, the Norris-LaGuardia Act gave employees the right to do so, but it didn't give them any specific powers or tools to accomplish this. This was changed in 1935 when the National Labor Relations Act was passed. Now, it expanded upon the Norris-LaGuardia Act. It gave employees the specific right to form, join, and promote unions. And it gave them the tools to do so. And what are those tools? Striking and picketing. It also gave employees the specific right to bargain collectively, collective bargaining. Now, this is really what unions are all about, collective bargaining. The idea behind it is that you can negotiate your own deal with the employer. As a matter of fact, all of you individuals can negotiate your own deal with your employer. But really, you're going to get the best deal if we all bargain together. In other words, if we bargain collectively. That's the idea behind it. And that's what unions are about, collective bargaining. So the National Labor Relations Act gave employees a specific right to form unions, to promote them, and the tools to accomplish this, as well as the right to collective bargaining. The National Labor Relations Act also set up the National Labor Relations Board. Now, the National Labor Relations Board is a really powerful federal agency. We're going to talk about them shortly. Basically, what that body does, 5 members, they're nominated by the president and approved by the Senate, very powerful body, and they oversee union elections. And we'll talk about those shortly. But the National Labor Relations Board was set up by the National Labor Relations Act. The next really big piece of legislation was the Labor Management Relations Act. Now, this was passed after World War II, 1947. It expands upon the activities that unions and employees can engage in to promote unionization. And it also gave employers the specific right for free speech to oppose unionization. But it's really not that free. We'll talk about that shortly. So it gave employers basically free speech rights to oppose unionization. And we'll talk about that briefly. How do you unionize? The Labor Management Relations Act of 1947 also, very importantly, gave the President of the United States the power to end any strike that the President deemed threatened national security. This only happened once during the Korean War. A group of steelworkers in Youngstown, Ohio went on strike. Well, during the Korean War, what do you need? You need weapons, you need tanks, you need planes, you need armaments. What are they made from? They're made from steel. So it only happened one time. President Truman sent in the National Guard and ended the strike. All right. Now, we talked about briefly the National Labor Relations Board, and what they do is they oversee union elections. Well, what does that mean? When we talk about unionization, it can't be forced upon the employees, it can't be forced upon the workers. They have to vote for it. There has to be an election. So how does that happen? Well, the first step is the would-be union has got to identify a bargaining unit. Kind of like a logical group of employees or workers. Maybe they have the same, maybe they all work in the same factory. Maybe they all have the same job responsibilities. Like for instance, nurses, right? They have unions, very powerful unions in some instances. But who else works in the hospital? So we have a nurses union. They represent the collective bargaining unit of nurses, and it makes sense in that respect. But what about electricians that work in hospitals? Well, for the most part, they're not represented by the same union that represents the nurses. They're part of a different bargaining unit. Most electricians in hospitals, at least on Long Island, where I'm from, are represented by the IBEW, the International Brotherhood of Electrical Workers. So again, the first step to any union election is the would-be union, the union that wants to represent these employees, that wants to represent these workers in collective bargaining negotiations, has to identify a bargaining unit. Second, the would-be union has got to establish, by basically signatures, that at least 30% of those members of the bargaining unit would vote yes to the union. Yes, I want to be represented by the union. If the would-be union can prove that, they can petition the National Labor Relations Board to set down a date for union elections. Provided they can do that, the National Labor Relations Board will set down a date. Now you have two types of union elections. You have contested elections and uncontested elections. Contested elections are when the employer is opposing the unionization of its workers. With contested elections, the National Labor Relations Board must oversee that election. What do they oversee the election for? Unfair labor practices, and we'll talk about those shortly. What constitutes an unfair labor practice? If the National Labor Relations Board determines that one side or another engaged in an unfair labor practice, it can order a new election, a new union election. There are uncontested elections as well, and that's where the employer is not opposing unionization. Now, in that instance, the National Labor Relations Board does not have to oversee that election. If they don't want to, they don't have to. There are also decertification elections, and that's when the bargaining unit, the employees, are voting to get rid of the union. In decertification elections, the National Labor Relations Board also has to monitor the election. All right, so the National Labor Relations Board is monitoring the union election. The union representatives are trying to convince the employees, the workers, to vote yes for the union. The employer is opposing it. And the National Labor Relations Board is making sure that neither side engages in an unfair labor practice. Well, what is an unfair labor practice? From the employer's point of view, it's anything that could be considered retaliatory. If you vote for this union, you're going to lose your job. If you vote for this union, I'm closing this plant. If you vote for this union, I'm going to fire you. Oh, and by the way, you're too old to get another job, aren't you? So anything that could be considered retaliatory for a union vote, even if it is factual, is considered unfair labor practice. From the employee's point of view, from the union's point of view, what's an unfair labor practice? Well, basically anything that's considered a crime, threatening harm or physical injury to someone's person or property, vandalism, stuff like anything that could be considered a crime is an unfair labor practice. Those are just two rules of thumb. All right, so what if the employees vote yes to the union? At that point, the union representatives now represent the employees. The employer must sit down and negotiate with them. Now, what do they negotiate? They have to negotiate wages. The employer does. They must negotiate wages, hours, benefits, and work assignments. They cannot discuss plant closings, discrimination, and stuff like that. So they got to discuss. The employer is forced to discuss wages, hours, benefits, and work assignments. So that's basically collective bargaining. And the collective bargaining agreement is a contract. It's a contract that governs the relationship between the employees and the employer. All right, so that's unionization. Now, there are some other important laws that you should know about, and then we're going to talk about discrimination in the workplace shortly. One important law is the Occupational Safety and Health Act, also known as OSHA. That was passed in 1970. It promotes safety in the workplace. There's the Fair Labor Standards Act, and this is a really important piece of legislation. This was passed during the Great Depression. It's been amended over time, but basically it sets minimum wage and overtime requirements. It also limits the use of child labor. Doesn't forbid it. Children can work at a certain age, but it limits what they can do and how many hours they can work, basically. So the Fair Labor Standards Act is still a really important statute. There's the Family Medical Leave Act, and what this does is it guarantees workers unpaid time off for medical emergencies. And this applies only to employers with 50 or more employees. And there's the Plant Closing Act. And that requires the employers to give 60 days notice to their employees if they're going to close a plant. All right. The next really important piece of legislation is the Civil Rights Act of 1964. A monumental piece of legislation, and it's huge. It's got 10, 11, 12 different titles. What we're going to do is we're going to focus on Title VII. Now, Title VII was originally called the Fair Employment Practices Act. It was subsequently amended to be called the Equal Employment Opportunity Act. And what it does is it does two things. It prohibits an employer from failing or refusing to hire or discharge or otherwise discriminate against an employee or an applicant based on race, color, national origin, sex, or religion. Now, a good mnemonic device for remembering those categories is CORES. C, color, O, national origin, R, race, R, religion, and S, sex. It also prohibits an employer from limiting, segregating, or classifying employees or applicants based on color, national origin, race, religion, or sex. Now, there are two basic types of lawsuits to come out of Title VII. Oh, by the way, what's not on that list? Sexual orientation is not on the list, and also transgender. That's not on the list, but that doesn't mean that there are state laws or local laws, like in New York City, that don't include them as protected categories. So you got to keep that in mind. As a matter of fact, in New York, in both the city and the state, they are protected categories. So you got to keep that in mind. So although you might be in compliance with Title VII of federal law, there might be state or local laws that protect that category. Now, there are two basic types of Title VII lawsuits. The first is disparate, D-I-S-P-A-R-A-T-E, treatment discrimination lawsuits. Now, these apply to the individual. It's the individual who is alleging discrimination based on their color, national origin, race, religion, or sex. Now, for an individual to bring a disparate treatment discrimination lawsuit, they have to establish, one, that they belong to a protected category. In other words, they were discriminated against based on the classifications we discussed. Two, that they applied for and were qualified for the job. Three, despite this, they were rejected for the job. And four, this is important, that the employer kept the job posting open with the same qualifications. If the plaintiff can establish all four of these elements, they have established a prima facie, P-R-I-M-A, facie, F-A-C-I-E, case. And it then shifts the burden from the employee or the applicant to the employer to prove that there wasn't a discriminatory reason for the non-hiring or failure to promote, or whatever the case may be. So, disparate treatment discrimination lawsuit. We'll talk about some defenses to Title VII shortly. The second type of Title VII action involves groups, where groups are alleging that they have been discriminated against. And these are referred to as disparate impact discrimination lawsuits. And it arises out of an allegation that an employer discriminated against an entire protected class. Often these lawsuits are brought as class action lawsuits. There are two elements. One, you have to have a statistical anomaly. So just to throw it out there, suppose I was an employer in Alaska, and in the county I lived in, 90% of the population were some kind of Eskimo, and 10% were others. When you looked at my workforce, it was the reverse. Only 10% of my workforce was Eskimo, and the other 90%, everyone else. Well, a statistical anomaly is the first step, but it's not enough. A statistical anomaly like that is not enough in and of itself to bring a disparate impact discrimination lawsuit. The plaintiffs also must establish that the employer had a policy in effect, that caused this statistical anomaly. Now, it's not going to be, it never is overtly racist or discriminatory in any way. It never is, or very rarely, I should say. It could be something completely nefarious. I mean, suppose, for instance, I wanted to open up a surf shop, and my branding involves, say, like late 50s, early 60s, Southern California. Like, I really want to capture that era. And I said, all of my employees, I only hire blondes. Now, on the face of it, am I discriminating against someone because of color, national origin, race, religion, or sex? No, I'm discriminating based on hair color. But de facto, wouldn't that result in a statistical anomaly against certain groups? the majority of my employees would probably be from Europe, most likely Northern Europe. On the other hand, applicants who apply, qualified applicants who apply, whose origin may be the Mediterranean, Africa, Asia, whatever the case may be. Although I'm not discriminating against them based on national origin or their race, still, it would have a disproportionate impact on those categories. So a disparate impact discrimination lawsuit, really important. Now, in either case, whether you're bringing a disparate treatment discrimination lawsuit or a disparate impact discrimination lawsuit, the plaintiff must file their complaint with the Equal Employment Opportunity Commission. They are the federal agency responsible for enforcing most federal anti-discrimination laws. What the EEOC will do is make a determination. Either they will bring the lawsuit on the plaintiff's behalf, or they'll give the plaintiff a right to sue letter. In other words, plaintiff or plaintiffs, we're not going to sue on your behalf, but you can do it on your own. Go ahead and good luck. But in either case, you have to first, as a plaintiff in a Title VII action, you got to give that complaint to the EEOC. An important first step. Now, what are some defenses to Title VII? Actually, before we do that, let's talk about some specific cases. Under Title VII, it applies to sex, in particular sex discrimination. Now, it applies to both men and women, obviously, but overwhelmingly, women bring the 98% of sex discrimination cases. It also includes, Title VII was amended to include pregnancy. There was the Pregnancy Discrimination Act. So it does cover sex discrimination. It also covers sexual harassment. Now, basically, there are two types of sexual harassment. There is hostile work environment, in which people are engaged in extremely offensive conduct. And there's also quid pro quo sex discrimination. In other words, if you want some kind of employment benefit, you have to give me sex. Quid pro quo. So those are the two types of sex discrimination lawsuits. It also applies, as we discussed, to religious discrimination. Now, religious discrimination cases are really a difficult thing for plaintiffs to prove. The employer has to make reasonable accommodations for their employee to observe their religion, to practice their religion. But does that mean, for instance, in retail, one of the two, maybe three biggest selling days in the week? Well, Saturday, Sunday, and perhaps Friday evening. Does that mean a Sabbatarian, someone who worships on Saturday, can tell their employer, I'm a Sabbatarian and I want Saturday off, and the employer has to comply? Well, no. No, actually, in those situations, a valid defense, a very strong and powerful defense is, although employers have to provide reasonable accommodations for their employees to practice their religion, to observe their religion, they do not have to do so if permitting, making these reasonable accommodations would result in undue hardship. So with retailers, for instance, employers who are retailers, they're faced with this situation a lot. Someone wants off on a Saturday or Sunday for a religious reason. Well, those are the two biggest selling days of the week, typically Monday through Friday. Monday through Sunday. Those are the two biggest selling days of the week. It's important that what? There are as many people out on the floor and in the stockroom to maximize those sales. So they've been pretty good, the employers have, of arguing that, you know what? This is going to result in undue hardship. All right, so what are some defenses to Title VII? Well, one is merit. But it's got to be related to a job requirement. But merit is a valid defense. Um, when we talked about the Constitution and the 14th Amendment, it's very similar to that. We talked about firefighters. Discrimination based on sex is okay as long as it's reasonably related to a legitimate government purpose. Well, here too, merit, it's got to be reasonably related to a job requirement. So along the same lines, fire departments have been pretty successful in arguing that um, the physical requirements to becoming a firefighter do in fact relate to the job. So merit, but it's got to be a job requirement. Another defense is seniority, plain and simple. Seniority, clear cut. The reason why that person got the promotion and not you, they were here longer. Seniority. A third, and this kind of gets interesting and fun, is a bona fide occupational qualification. What does that mean? Well, it allows discrimination other than race or color, and I believe probably also national origin, although I'm not aware of any cases along those lines. It allows for discrimination if it can be shown that there is a bona fide business reason for it, a bona fide occupational reason for it. So what would be an example of that? Well, I'm sure all of you have heard of Curves. Now, Curves is a gym with a female clientele. Now, obviously, there's a locker room at Curves. What if a man wanted to apply for a position as a locker room attendant at Curves? What if a man walked in? I saw the job listing for a locker room attendant. I have a lot of experience being a locker room attendant. I am qualified for the job. I can give you references about what a great employee I am and will be for you. So when do I start? Well, obviously, Curves might have some apprehension about hiring a man to be a female locker room attendant. Why? Because obviously, they can probably make a pretty good case that the clientele isn't going to be too happy about it or too comfortable with it. What if, on the other hand, so that would be a bona fide occupational qualification. What if, on the other hand, though, it was not a position of locker room attendant, but manager at Curves? So really, it's more of a supervisory position. Could they make the same case? I think that might be a little bit more difficult for them. Certainly being a manager doesn't necessarily require they go into the locker room. That's what they're there to do, manage people who go into the locker room. You go in the locker room and do it. They may have a little more difficult case making that argument. So that's something to keep in mind. All right, so those are some defenses to Title VII. I want to talk briefly about the Equal Pay Act. Basically, it prohibits discrimination based on sex if the job requires equal skill, effort, responsibility, and similar working conditions. So are there defenses to that as well? Well, just to back up for a second, that's often a tough thing to really establish, equal skill, effort, and responsibility in working conditions. But assuming you can get over that hurdle, are there defenses to the Equal Pay Act? Well, they're kind of similar to defenses to Title VII. One is seniority. The other is merit, as long as there is an identifiable and measurable standard by which you can measure the employee's production. Another is quantity. For instance, in sales, people are often paid by commission. So if that can explain the pay disparity, that's also another defense. and any other factors that might come into play. For instance, there may be a pay differential due to night versus day shift. Now, most people, for instance, the New York City Department of Sanitation, if you work the overnight shift, you do get an extra bonus in your paycheck. Why? Well, most people prefer to what? Work during the day. But as incentive to get people to work at night, they give them a little extra bonus. So if that explains the pay inequality, then that is fine as well. Just a couple of other acts I just want to mention. There's the Age Discrimination and Employment Act. I am covered by that. It covers people 40 to 70. And there's the Americans with Disabilities Act, and basically it requires that employers and those who provide public transportation and telecommunications provide reasonable accommodations for people with disabilities. I'm not going to get too far into it, but I am going to say it's probably one of the worst pieces of legislation ever written. The intended effect was supposed to make it easier for people with disabilities to find employment. But the fact of the matter is it's made it harder for people with disabilities to find employment, mostly because potential employers are concerned with lawsuits. But I don't really like to pontificate, but I just don't like that act, the Americans with Disability Act. It was well-meaning, but it had the opposite intended effect. But that's it. Next lecture we're going to discuss agency. Keep taking good notes, and this week we're going to have a discussion board, so keep an eye out for that. All right, thank you.